Section 41. This Act not affected by agreements. Subject to the provisions of Sections 10.4 and 37.2, a provision of this Act or a condition specified in any notice or direction issued thereunder or subject to which exemption was granted to any person under Section 40 shall not be affected by any condition of any agreement, whether such agreement was entered into before or after the commencement of this Act, or before or after the imposition of any such condition, as the case may be. An agreement or legally binding arrangement between parties as to a course of action will not be able to affect the conditions of the OHS Act being enforced. In other words, no matter what the agreements are in place by an employer, you will always be liable for the requirements of this Act, unless you have a mandatory 37.2 agreement which is in accordance with this Act, or you have been exempted by the Minister in accordance with Section 40 of this Act. Section 42. Delegation and assignment of functions. The Minister may delegate any power conferred upon him by or under this Act, except the power contemplated in Section 43, to an officer. A delegation under subsection 1 shall not prevent the exercise of the relevant power by the Minister himself. The Minister may authorize any provincial administration or local authority to perform any function referred to in this Act. An authorization under Section 3 shall not prevent the performance of the relevant functions by the Minister, the Chief Inspector, or an Inspector, as the case may be. This means that the Minister may delegate any power that this Act allows them to have, except making regulations as shown in Section 43 of this Act. They can also authorize any provincial administration or local authority to perform any functions in order to carry out any section of this Act. This delegation of power does not mean that the Minister no longer has the power. The Minister still continues to have overall power with regards to this Act, and this is the same for the functions of the Chief Inspector or an Inspector from the Department of Labour. Section 43. Regulations. The Minister may make regulations as to any matter which in terms of this Act shall or may be prescribed, which in the opinion of the Minister are necessary or expedient in the interest of the health and safety of persons at work or the health and safety of persons in connection with the use of plant or machinery, or the protection of persons other than persons at work against risks to health and safety arising from or connected with the activities of persons at work, including regulations as to the planning, layout, construction, use, alteration, repair, maintenance, or demolition of buildings, the design, manufacture, construction, installation, operation, use, handling, alteration, repair, maintenance or conveyance of plant, machinery, or health and safety equipment, the training, safety equipment or facilities to be provided by employers or users, the persons to whom and the circumstances in which they are to be provided and the application thereof, the health or safety measures to be taken by employers or users, the occupational hygiene measures to be taken by employers or users, any matter regarding the biological monitoring or medical surveillance of employees, the production, processing, use, handling, storage or transport of, and the exposure of employees and other persons to hazardous articles, substances or organisms, or potentially hazardous articles, substances or organisms, including specific limits, thresholds or indices of or for such exposure, the performance of work work in hazardous or potentially hazardous conditions or circumstances. The emergency equipment and medicine to be held available by employers and users. The places where such equipment and medicine are to be held. The requirements with which such equipment and medicine shall comply. The inspection of such equipment and medicine. The application of first aid and the qualifications which persons applying first aid shall possess. The compilation by employers of health and safety directives in respect of a workplace. The matters to be dealt with in such directives and the manner in which such directives shall be brought to the attention of employees and other persons at a workplace. The registration of persons performing hazardous work or using or handling plant or machinery. The qualifications which such persons shall possess and the fees payable to the state in respect of such registration. The accreditation, functions, duties, and activities of approved inspection authorities. The consultations between an employer and employees on matters of health and safety. Subject to Section 36, the provision of information by an employer or user to employees or the public on any matter to which this Act relates. The conditions under which any employer is prohibited from permitting any person to partake of food or to smoke on or in any premises where a specified activity is carried out. The conditions under which the manufacture of explosives and activities incidental thereto may take place. As to the preventative and protective measures for major hazard installations, with a view to the protection of employees and the public against the risk of major incidents. As to the registration of premises where employees perform any work or where plant or machinery is used, and the fee payable to the state in respect of such registration. Whereby provision is made for the continuation of any registration under this Act. As to the registration of plant and machinery and the fee payable to the state in respect of such registration. As to the establishment of one or more committees for the administration of a provision of the regulations, the constitution of such committees, the functions of such committees, the procedure to be followed at meetings of such committees, the allowances which may be paid to members of such committees from money appropriated by Parliament for such purpose, and the person by whom such allowances shall be fixed. Prescribing the records to be kept and the returns to be rendered by employers and users, and the person or persons to whom such returns shall be rendered. As to the designation and functions of health and safety representatives and health and safety committees and the training of health and safety representatives. As to the activities of self-employed persons and as to any other matter the regulation of which is in the opinion of the Minister necessary or desirable for the effective carrying out of the provisions of this Act. No regulation shall be made by the Minister except after consultation with the Council, and no regulation relating to state income or expenditure or to any health matter shall be made to the Minister except after consultation with the Minister of State Expenditure and the Minister for National Health and Welfare, respectively. In making regulations, the Minister may apply any method of differentiation that he may deem advisable, provided that no differentiation on the basis of race or color shall be made. A regulation may in respect of any contravention thereof or failure to comply therewith prescribe a penalty of a fine or imprisonment for a period not exceeding 12 months, and, in the case of a continuous offence, not exceeding an additional fine of 200 Rand or additional imprisonment of 1 day for each day on which the offence continues, provided that the period of such additional imprisonment shall not exceed 90 days. A regulation made under Section 35 of the Machinery and Occupational Safety Act of 1983, which was in force immediately prior to the commencement of this Act, and which could have been made under this section, shall be deemed to have been made under this section. Basically what this means is that the Minister may also make additional regulations in the interest of health and safety. This can be seen in the regulations that have been made for construction, ergonomics, asbestos, and the like. The regulations will be created so that the interest of the health and safety of persons at work, or the health and safety of persons in connection with the use of plant or machinery, the protection of persons other than persons at work against any risks to health and safety arising from or connected with the activities of persons at work are met. Now, these regulations can include all the items as we've discussed in this section. No regulation, however, can be made by the Minister except after consultation with the Council, and no regulation relating to state income or expenditure or to health and safety matters shall be made by the Minister unless he has consulted with the Minister of State Expenditure as well as the Minister for National Health and Welfare. Now, in making these regulations, the Minister may apply any method of differentiation. This is the act or process of differentiating or distinguishing between two or more things or people. But he is not allowed to make a differentiation on the basis of race or color. Now, failure to comply with a regulation may mean that you are issued a penalty or a fine or even imprisonment for a period not exceeding 12 months. Now, in the case of a continuous offense, not exceeding an additional fine of 200 Rand or additional imprisonment of 1 day for each day on which the offense continues. The period of such additional imprisonment is not allowed to exceed 90 days. Any regulation that was made in the previous Health and Safety Act under Section 35 of the Machinery and Occupational Safety Act of 1983 and was in force immediately prior to the start of this Act, and which could have been made under this section, will be deemed to have been made under this section, and in other words is still enforced currently. Do you know what regulations affect your work? And have you made a register of which regulations affect the entire scope of your work? Have you made provisions to adhere to their requirements and ensure you are protecting your employees as well as others who may be affected by your work against the risks and hazards? Section 44. Incorporation of health and safety standards in regulations. The Minister may by notice in the Gazette incorporate in the regulations any health and safety standard or part thereof, without stating the text thereof, by mere reference to the number, title, and year of issue of that health and safety standard, or to any other particulars by which that health and safety standard is sufficiently identified. No health and safety standard shall be incorporated in the regulations except after consultation with the Council. Any health and safety standard incorporated in the regulations under subsection 1 shall, for the purposes of this Act, insofar as it is not repugnant to any regulation made under section 43, be deemed to be a regulation, but not before the expiry of 2 months from the date of incorporation thereof. Whenever any health and safety standard is at any time after the incorporation thereof as aforesaid amended or substituted by the competent authority, the notice incorporating that health and safety standard shall, unless otherwise stated therein, be deemed to refer to that health and safety standard as so amended or substituted as the case may be. The Chief Inspector shall keep a register of particulars of every publication in which a health and safety standard incorporated in the regulations under subsection 1 and every amendment or substitution of any health and safety standard was published, and also of the place in the Republic where such publication is obtainable or otherwise available for inspection. and he shall make that register or an extract therefrom available free of charge to persons having an interest for inspection. The provisions of Section 31 of the Standards Act of 1993 shall not apply to any incorporation of a health and safety standard or of any amendment or substitution of a health and safety standard under this section. Any safety standard which was immediately prior to the commencement of this Act incorporated under Section 36 of the Machinery and Occupational Safety Act of 1983 in the regulations made under this Act shall be deemed to be a health and safety standard incorporated under this section. This means that the Minister may incorporate, which is take in, contain something as part of or whole of, or to include any health and safety standard or part of that standard without needing to write out the entire standard. It can only be incorporated after consulting with the Council, and this must be issued in a notice by Government Gazette. The Minister may ensure that the standard is identified by reference to a number, title, and year of issue of that health and safety standard, or by any particulars by which that health and safety standard is sufficiently identified. As long as the health and safety standard does not conflict with this Act or any regulations, then the standard shall be deemed a regulation, but not before the expiry of 2 months from the date of incorporation. If the notice of the Government Gazette speaks about including any standard, and after this notice is issued, the standard is amended or substituted, then unless it is otherwise stated in that notice, it will be accepted that the original notice by Government Gazette is referring to that amended or substituted standard. The Chief Inspector must keep a register of all of the above, all the notices, amendments, substitutions of this Act, the regulations or standards, and this has to be kept as public record, as well as be made available for any person who wishes to inspect these documents. Now, the provisions of Section 31 of the Standards Act does not apply to any incorporation of a health and safety standard or any amendment or substitution of a health and safety standard under this specific section. Any safety standard which was immediately prior to the commencement of the Act already incorporated under Section 36 of the old Machinery and Occupational Safety Act of 1983 will be deemed to be a health and safety standard incorporated under this section. Section 45. Serving of notices. Unless another method is prescribed, a notice under this Act shall be served by delivering a copy thereof to the person upon whom it is to be served, by leaving a copy at the usual or last known place of residence or business of such a person, or by sending such a copy by registered post to the usual or last known place of residence or business of such a person. This means that a copy of the notice that is issued under this Act must be either delivered to the person it is served, left at the usual or last known place of residence or business of that person, or sent by registered post to the usual or last known place of residence or business of that person. Section 46. Jurisdiction of Magistrates' Court. Notwithstanding anything to the contrary contained in any law, a magistrate's court shall have jurisdiction to impose any penalty or to make any order provided for in this Act. No magistrate's court shall be competent to pronounce upon the validity of any regulation made under this Act. This is fairly self-explanatory. What does it mean? Well, a magistrate's court shall have jurisdiction to impose any penalty or to make any order provided for in this Act. However, a magistrate's court shall not be competent to pronounce upon the validity or legality of any regulation made under this Act. Section 47. State-bound. This Act shall bind the state. Simply put, this Act is applicable to all unless exempted by the Minister within South Africa, and by this Act we are bound. Section 48. Conflict of Provisions. Insofar as any provision of the Explosives Act of 1956 is repugnant to a provision of this Act, the provisions of this Act shall apply. This means that if any provision of the Explosives Act of 1956 conflicts with the Occupational Health and Safety Act, then the Health and Safety Act shall be the requirement to apply. In other words, this Act, the Occupational Health and Safety Act, will supersede or be above the conflicting provisions. Section 49. Repeal of laws. The Machinery and Occupational Safety Act of 1983, the Machinery and Occupational Safety Amendment Act of 1989, and the Machinery and Occupational Safety Amendment Act of 1991 are hereby repealed. Repeal means to take away or cancel, so we no longer need to comply with the requirements of previous acts. These are the Machinery and Occupational Safety Act of 1983, the Machinery and Occupational Safety Amendment Act of 1989, as well as the Machinery and Occupational Safety Amendment Act of 1991. The Occupational Health and Safety Act is now the current act to be in place. In future, this act could be amended or replaced, and the Minister will let us know which act to conform to. For now, we adhere to the OHS Act. Section 50. Short title and commencement. This Act shall be called the Occupational Health and Safety Act 1993 and shall come into operation on a date fixed by the State President by proclamation in the Gazette. Different dates may be so fixed in respect of different provisions of this Act. This Act shall be called the Occupational Health and Safety Act, and it came into operation on the date it was stated in the Gazette. There may be different dates in respect of different provisions of this Act.